Hi friends, the 130th Constitutional Amendment Bill has been introduced in the Lok Sabha and it has been referred to a joint parliamentary committee. This bill seeks to amend the provisions with respect to Council of Ministers. It states that if any minister, including the Chief Minister at the state level or including the Prime Minister at the union level, any minister who is arrested and detained for 30 consecutive days in a criminal case where the punishment will be 5 years or more, then they will automatically lose their ministership at the end of those 30 days. The Prime Minister or Chief Minister should advise the President or Governor to drop them from the Council of Ministers. Otherwise, they will automatically lose their ministership. Same applies to PM and CM. Either they should either resign or they will lose their ministership. Now, this is because the government says, how can a minister be in jail? How will the ministry function? Fair point. There's so much of criminalization of politics and there must be a full stop to it. Earlier, taking moral grounds, people used to resign if they are arrested. But now, there was a case in Tamil Nadu where a minister continued for many months. After that, he eventually resigned. Then he got bail also. Then he was again made a minister. The court again asked, "Are you want bail or you want to become a minister? What is the urgency in making him a minister again?" And so he has resigned again. In Delhi, there were ministers who were arrested, including the chief minister who continued in office for a long period of time. So the government is saying this has become the new normal. So we should address this. People will lose confidence in the democracy if Council of Ministers operate out of jail. Very valid points. But what are the issues? The issue is, look, arrest is just a police action. Criminal jurisprudence says unless you are proved guilty, you are innocent. That is why the MLAs or MPs lose their seat not because they are arrested, not even when a charge sheet is framed. They lose their seat membership only if they are convicted in a criminal case for minimum 2 years and then they lose their seat. So, how can you suddenly make a minister lose the seat, just lose the ministership, just by police action? So, it is against the protection, under fundamental rights under Article 21, 20 and all, where you cannot, you have a fundamental right to remain innocent till you are proven guilty, right? So, this is one aspect. The second aspect is parliamentary democracy. The PM or the CM chooses their cabinet. Now you are forcing the PM or CM to drop a minister just because they are detained by police. But most importantly, in real practice, this may be misused primarily by the central government. See, can you imagine whether a state government CM or minister will be arrested by the state police? It will never happen in India, right? Because the state police is under the state government. Do you think any central agency will go and arrest a central minister unless it is very evident crime or anything? It will never happen. So what will actually happen because of this amendment? This will give powers to the center through the central agencies like CBI, ED, NIA and all to go and target and arrest opposition ruled state chief ministers or opposition ruled state ministers, put them in jail for minimum 30 days and then make them lose their ministership. This is the allegation of the opposition parties. There is some merit in this argument because in reality, this is what will happen. Any central government can go against opposition ruled state governments and so they are opposing it. So you need probity in public life. People should have the confidence. Criminalization of politics should come down, but it cannot be as blunt like this. What can be the way forward? See, one way forward is Election Commission had recommended that if you are charge sheeted, not just arrested, a charge sheet by a competent court has to be filed. Charges have to be filed with the permission of a competent court for an offense where the punishment is minimum 5 years. Then Election Commission had recommended that such people should not contest elections, though that amendment has not been made to the Representation of the People Act. But that can be a solution here, where just because of arrest, you will not lose your ministership. But if you are charge sheeted by a competent court for an offense which is punishable with an imprisonment of minimum 5 years, at least 5 years, then the ministership will be lost till the charges are cleared. That could probably be a solution which, or an independent tribunal headed by a judge who decides whether these conditions are satisfied or not for removal from ministership. These safeguards may be considered by the Joint Parliamentary Committee. But guys, all this is the effect. What is the cause? The cause is because so many criminally tainted candidates are given seats to contest elections. Association of Democratic Reforms has said that 46% of our Lok Sabha MPs have criminal cases against them. In another report, they said out of 4,123 MLAs in various states and 3 union territories, 45% have criminal cases against them. It cuts across. There is unity across party lines, be it national parties, be it state parties, be it regional parties. Everybody has criminal background members. And that is what is the basis for the Council of Ministers in our parliamentary democracy. So the real solution for this in the long run is if you stop giving tickets to criminally tainted candidates. That is the real reform that is required through self-discipline of the parties so that this criminalization of politics will come down. Thank you.